Ms. Graham.
Thank you. I was about to move on to ask you some questions about the letter of instruction that was sent to Martin Graves. That was dated the 24th of January 2018, but before that was sent, there was an email exchange with you and Les Brown, and I'd like to ask you about that. And that relates to let's look at a minute. Crown Office document COPFS 02214A, and we'll have that on the screen. And this is a minute from Les Brown, head of CAPD, and you were copied in to this minute, which was to the law officers. And if we could look please at paragraph 3 on page 1. There was the discussion set out there, the dedicated AD Ashley Edwards QC. So this is end of November 2017, before you actually instruct Martin Graves. Discussed the ongoing investigation with members of the team on the 15th of November and reflected on the analysis of the statements provided by officers involved in the restraint process that has been carried out by the investigative team, and the perception that these may not reflect the true picture. Consideration will therefore be given to identifying officers whose involvement in the incident is remote and who may be recognised by the Crown. Can you help the Chair understand the remark here, a perception that these may not reflect the true picture in relation to the statements provided by the officers? Can you tell us a little bit more about that?
Obviously, I didn't write the minute, so I'm not entirely sure what was in the mind of, I think you said to me it was from Les Brown.
It does say, however, the dedicated AD Ashley Edwards QC discussed the ongoing investigation with members of the team on the 15th of November, which was prior to this minute being prepared, just a matter of days, and reflected on the analysis of the statements provided by officers involved in the restraint process that has been carried out by the investigative team, and the perception that these may not reflect the true picture.
So I'm not sure about the choice of the word perception, but
Right.
the process that we were going through continuously was questioning the actual factual matrix. So we were testing one statement against another. We were looking at the content of the statements. If something didn't quite ring true, then we were concerned about that. You highlighted to me earlier bits missing in a statement of Ashley Wise. That again is factored in, so we're concerned that there's something more going on than just the what we see in a particular statement. So I think that's all that is talking about, that we are testing as we're going along whether one statement contains evidence that can be supported by another statement, and continually testing.
And was it the case that it was acknowledged and recognised by the team and yourself that there were different versions of events as to what happened?
Absolutely. And that, I think an example of that was the different body positions that Mr. Bauer was said to be on the ground. Face down all the time, on his back all the time, lying down with his legs up, bent backwards, on his side. So we were aware that all those different viewpoints had come through the statements. And one of the things that we were looking at was to try and see how we could support or discredit those individual elements.
And were you also interested in exploring with the experts the extent to which those versions and those descriptions of different body positions may or may not have impacted on their opinions?
I can't remember what point the body positions, the actual body positions, if you're talking about the multimedia, I can't recall what point they came into being, but certainly it was known from an early stage that they couldn't all be correct. And so we were trying to reconcile one with the other. Is it possible that Mr. Bio was in position X at one particular time, in an early part of the restraint, or a later part of the restraint, in another position at a different point of time, where the angle that the witnesses were looking, did that affect the evidence? That was the sort of thing that we were looking at. We were continually trying to test the information that we had.
So there was an acknowledgement that in terms of the evidence, the multiple statements that were available to the Crown, not all could be truthful and accurate.
Correct.
It wouldn't be for you to decide which were maybe untruthful or inaccurate, but there was an issue there about the different versions that were presented and available to the Crown, and it wasn't for you to decide who was telling the truth and who was reliable in their memory and accurate.
And that's what made me pause before I answered there, because the question said truthful and reliable, and yes, it wasn't for me to decide at that stage. But what it was for me to decide was the Crown case, potential Crown case, or a case that could be at its highest.
Right. And as part of exploring that, where you did have different versions, it not being for you to make a decision on that, you would have to manage that situation, because you would not be in a position to say this is what's true and this is what's accurate and ignore everything else.
Sometimes when we looked at the facts, we were able to say actually that can't be right, or that witness cannot have seen that, because simply when we looked at maybe the CCTV, we knew that that wasn't supported, the witness wasn't there at that point. So those are we were able to discount some of the eyewitness evidence.
Right. And do you remember any specific examples of where you simply discounted the eyewitness evidence?
I don't know if maybe that was an imprecise use of words. Maybe we didn't completely discount it, but we certainly looked at it and thought, well, perhaps that is not right.
So where you had a situation where maybe you thought maybe perhaps that's not right, would you simply push it to one side, maybe not discount it as such, but push it to one side and not address that with experts and with your investigations? Or would you retain that and address it as part of your investigations?
It depended on the nature of the piece of evidence and what we had to contradict it. If it was something very strong to contradict it, it may be that I might not have mentioned it. But I don't recall with any of the experts that any of the statements were not included.
So in terms of the documents that were provided to experts, were you giving them the full picture or as much of the picture as you could?
As far as I'm aware, we were.
And none of those statements were discounted or removed so the expert could not have those available?
Not as far as I can recall.
And where there maybe were issues or questions in your mind in relation to credibility and reliability, that it would that make it more important that you made sure that the experts had the full picture of the versions that were put forward by witnesses?
Certainly all the statements anyway.
Right. All right, thank you. Can we...
But just before we move on,
Sorry.
because what I think that paragraph goes on to say was that what's being discussed there is not experts, but the potential for recognising some of the police officers.
Yes, I was asking about it specifically in relation to the wording, the perception that these statements may not reflect the true picture, and to flush out with you this issue of perhaps there were different versions of events available to the Crown at that time. Okay. And I think you've helped me with that. I'd like to move on now, please, to the letter of instruction that was sent to Martin Graves from Alistair MacLeod, and this is dated 24th of January 2018, and it's COPFS 00008, and it's dated, as you'll see, 24th January 2018 to Martin Graves. There's two passages I am particularly interested in looking at, although this is a lengthy letter that's been prepared. And the letter itself is 9 pages long, but I'm interested in 2 paragraphs. And I've, over the course of lunchtime, I've looked at every version that the inquiry has available. There are 9 versions with track changes, some from yourself and some from other members of the team. Now, if we could look at, you'll see it is the letter of instruction to Martin Graves. The first passage I'm interested is on paragraph 2, and it's in bold. Sorry, page 2. Sorry, that was my mistake. Page 2, you'll see it in bold, given your expertise. You see that on the screen? Having gone through the 9 versions available to the inquiry, I can tell you that the final sentence was one of the track changes that was added. We would ask that you consider all of the materials supplied to you in reaching your opinion. I personally don't want to labour that. That doesn't seem controversial. The part I'm interested in is the beginning of this paragraph. Given your expertise, the Crown wish to instruct you to prepare a report commenting on the actions of police from the point of engagement with Mr. Bio, and particularly providing opinion on whether the method of engagement with and restraint of the deceased by officers was reasonable and justifiable, taking into account the requirement for their use of force to be necessary, accountable, proportionate, legal and ethical. Now, we've heard evidence that the officers are permitted to use force as part of their duties, that can be lawful if it is justified, and it would be justified and lawful if the officer can explain why it was necessary to use force, why that was the minimum level, absolute minimum level of force that was needed to achieve their aims, whether it was reasonable. So they have to justify under reference to those concepts. And I think that's what's set out here in this letter of instruction. And in general, in providing your opinion, please comment on whether the officers concerned seem to have followed their OST training. And that was a supplementary matter. Now, looking at that paragraph, first of all, I asked James Wolfe about this paragraph and the phrase, whether the method of engagement with and restraint of the deceased by officers was reasonable and justifiable. And I asked him, on reading that, whether it appeared to be an invitation to Martin Graves to look at the evidence and essentially take a view which was ultimately a decision to be taken by the fact finder. In the case of a criminal trial, that would be the jury. I asked him if it was an invitation to read the evidence that was provided and to form his own judgment on the facts and to see whether he thought the restraint was reasonable. And I think I used the phrase, perhaps usurping the function of the court. But in effect, was this passing the responsibility to Martin Graves to form a view which was ultimately the function of the jury? And in taking that approach, we're really asking him to decide that issue, the issue that ultimately would be one for the jury. And in response, Mr. Wolfe said, the important point, after some discussion, I'm summarising his answer, the important point is that the factual basis upon which the view is reached is robust, or if there are alternative factual scenarios, that you know is explored and is patent in the ultimate view of the expert, so that the expert's opinion and the basis for it can be properly scrutinised and tested. Would you agree with Mr. Wolfe that it's important that the facts and the factual basis of any view are properly explored with the expert?
Certainly that the expert has the information that's necessary for them to come to that expert opinion, absolutely.
And Mr. Wolfe also talked about, he gave an example of a professional negligence case. And he said the type of question that may be asked in that would be whether the actions were consistent with what you would expect from an ordinarily competent member of a profession. And we also spoke about, in a criminal context, say in a Section 1 death by dangerous driving trial, that you would not ask a road traffic reconstruction expert, was the driving dangerous, because that would be a question exclusively for the jury. But you could ask the expert, how would a careful driver have driven along this road in these circumstances? What speed would a careful driver have? And the answer to that may be within a range. And you could even pose the question, would that careful driver drive at 90 miles an hour in the rain? But you couldn't ask the jury, or if you did ask the jury, was the driving dangerous, inviting the expert to make that decision, which is solely for the jury, that would be objectionable.
Agreed.
Would you agree with that?
If you were in a criminal trial and you
In
were
a criminal
talking
trial.
about evidence of admissibility, agreed.
And Mr. Wolfe agreed with those matters, and I asked him, is it possible that taking this approach, as written down in this letter of instruction, taking that approach with Mr. Graves could potentially give rise to a risk, or perhaps a temptation, to hand over responsibility for taking a view on the restraint and whether it was justified to the expert, and asking them to make that decision, and then simply there would be a risk that you could say, we accept what you said on that and we'll proceed on that basis, rather than the Crown applying its own independent thought processes. And do you consider, looking at the way that's phrased, and having agreed in relation to the points that we've been discussing, that there is a risk that posing that type of question to Martin Graves invites him to make his own decision and form his own conclusions about the factual position which is related to the events at Hayfield Road?
I can see what you're talking about and what you're getting at. I think we might have phrased it differently, so that we could have asked the questions in an admissible fashion, if you're talking about in a criminal trial evidence sphere. And we could have put in the way you phrased it, which was, what in the circumstances, what would you consider to be a reasonable approach? That might be a way to have approached it. I amn't concerned that the information that we got back in any way clouded or coloured or sent us, the investigation team, off in the wrong direction. If there was material in there that usurped the finding of a fact finder, then I would know, if I was going to use his evidence in a subsequent trial, I would know where to stop. And in fact, by that point, it would probably already have been objected to and excised from the report. And we may well have, if there was something in there and we were in a criminal trial, we may simply lodge a redacted statement or have an agreement in advance before starting evidence.
And yesterday, and we also spoke to Mr. Wolfe about this. We talked about a technique and a strategy that's used by, could be used by the Crown, is used by lawyers, where they appreciate and acknowledge the existence of different factual versions. And in order to explore fully each alternative version, that they develop hypotheses, factual hypotheses. And they can look at one version, see if this is accepted, let's explore the implications of that. And if it's not, and version 2 is accepted, you can look at the implications of that. And I think yesterday you talked about presenting a factual matrix which sets out and maintains the different versions that may exist in relation to any given incident.
And that sort of technique is the technique that you might use, that the Crown prosecutor might use when examining a Crown expert witness, but knowing that there's going to be particular challenges from a defence counsel or a defence expert, you might want to meet that head on in the Crown case and put that alternative hypothesis to the witness. Before you do that in court, you will have already have done that in consultation, because you want to know the answer before you do it.
So the consultation where you're sitting with the expert is your opportunity in a relaxed atmosphere to explore those different, potentially different factual versions of events.
And as we talked about yesterday, that might be in different consultations. It might not always be in the initial consultation. It might be in a subsequent consultation immediately before trial, or it might be at the stage that we're talking about.
But at the very least, in a consultation with an expert where there are different versions, you would want to have your core Crown theory of the fact, the most prejudicial version at least, explored fully with the expert.
And I think that's what we said yesterday, the Crown case at its highest.
Crown case at its highest, thank you. There's another section of this letter of instruction I'd like to look at, and that's page 7, and it's towards the bottom, and it talks about restraint on the ground. And you'll see that this is a section regarding the restraint part of the events in Hayfield Road. It refers to the CCTV timeline, which we talked about yesterday briefly, the duration. I'd like to look at the final paragraph of that. The Snapchat footage taken by witness Wise, inserted at 1 minute, 1 second into the restraint, contains a brief glimpse of the methods of restraint being used at that time. 6 officers are in various positions on around the now deceased. From that Snapchat footage, it appears Mr. Byle was lying on the southern pavement on Hayfield Road, surrounded by 5 police officers, namely PC Smith, PC Tomlinson, PC Payton, PC Gibson and PC McDonough. A 6th officer, believed to be PC Walker, appears to be lying lengthwise on top of or beside Mr. Byle, his high visibility clothing visible momentarily. Now, PC Walker is the officer who was 25 stone and I think 6'4". Would you say that this version, which is being given in this letter of instruction, was the most prejudicial version, the Crown version at its highest that was available?
I would say if he's lying on top of Mr. Byle, then absolutely. Because my recollection was that his position might have been that he was kneeling, but that some of his body weight might have been on the top of Mr. Byle. But of course, if his knees are on the ground, then not his full weight is on the upper part of Mr. Byle. So from looking at that and from my memory, that would be a less prejudicial position.
Thank you. I think we'll come on to that in a moment when we look at the report from Mr. Graves.
What also strikes me about that is that there's the mention of the high visibility clothing. I remember I didn't understand that, not necessarily at this stage, and I had asked to go back and have a look at the CCTV and for that to be explained to me, because I couldn't see that and I couldn't understand how that was relevant and how that related to that particular officer. So I remember looking at that in detail.
And did you ultimately resolve that, having reviewed the Snapchat footage?
Can't remember, but I'm not sure I did. I'm not sure that I was satisfied that the CCTV was sufficiently clear, but I certainly wanted it explained to me.
But regardless of your own personal views, this was setting out in the letter of instruction the Crown case at its highest, its most prejudicial.
With regard to that section,
aspect,
yes.
We're talking about the restraint section.
I would think with regard to that particular officer and the alternative position that I've just suggested, then I think yes. Okay. Lying on top is certainly more prejudicial.
The alternative isn't put there. It's simply the most prejudicial position. Do you have any comment about that? That the alternative factual hypothesis is not present there. Do you have any concerns about that?
My recollection is that there was a discussion about that witness simply his weight being on the top of Mr. Bio's body, that the upper part, and that was with the expert, but that's only my recollection at this stage.
Right. No, I mean in the letter of instruction. You obviously had an opportunity to review it. You did track changes. Did you, when you read that, think there should also be the alternative factual matrix, so the alternative factual hypotheses put, or did you take a view that that was sufficient because this represented the most prejudicial version?
I think I might have taken the view that the words beside was sufficient to convey that other position.
Right.
So kneeling beside.
Right.
It just doesn't go on to say with the weight on the upper part of the body. So I think as I'm looking at that now, I think that I was probably satisfied that that was sufficient in the letter of instruction to convey both positions.
Thank you. Could we now look at the report that Martin Graves produced, COPFS 00024, and I'd like to look at page 30. There are 41 pages on this PDF, and this is the report that ultimately was sent by Mr. Graves to the Crown. And I'm interested in, you'll see that on this page there are paragraph numbers. I'm interested, first of all, in S. There we are. And this is where Martin Graves talks about the factual position. And I'll go through a number of paragraphs with you just to put this in context. S. PC Walker also fell to the ground at this time, dropping the baton he'd taken from his colleague. He states he ended up on his knees next to Mr. Bio, who was on his back. So at the very least, Mr. Graves has acknowledged and noted that he was aware of PC Walker's version at this point, that he ended up on his knees next to Mr. Bio. And then if we can look at page 31, and this is in the taking to the ground and restraint of Mr. Bio's section, page 31, and if we look at, well, from D, he talks about the restraint and the information he had available. He talks at E. At the start of this process, PC Walker describes the subject lying on his left side with him, that is PC Walker, behind on his knees. He states he attempted to get hold of Mr. Bio and was placing some downward pressure on his shoulder with his upper body. And I think that's what you were talking about earlier. So Martin Graves recognised that there was a version given by PC Walker which was not aligned with the most prejudicial version available to the Crown. And then if we look at Jai, please. At this time, there are differing accounts of the body position of Mr. Bio. PC Tomlinson, Smith and Mr. Nelson appear to have him on his front, with PC Walker lying over his upper body. So that's the high point of the Crown case. And
it is, though, slightly different than the bit that you took me to before, because we were indicating that he was completely over Mr. Bio, lying on top of him, whereas here that looks slightly different.
Right.
It's lying across. The picture that paints for me is across the upper body.
Right, so what it says here is lying over his upper body.
But also from inference, all his weight on his upper body. So nothing to suggest that any other part is on the ground bearing his weight.
Right. So in the original section we looked at let me just see if I can find it. The position presented in the letter of instruction on page 7 was that PC Walker appeared to be lying lengthwise on top of or beside Mr. Bio. And here, Mr. Graves is stating in his report that Tomlinson, Smith and Nelson appear to have him on his front with PC Walker lying over his upper body. So there's nuance there between the versions.
I think so.
So that what's stated at JAI is not completely in line with the Crown's most prejudicial version, the high point of the Crown case, but it gives an example of one version at least from 3 of these witnesses. And PC Walker describes this as being on his knees with his upper body over the subject's right shoulder, with him lying on his left side. So what we have here in JAI is a description, Mr. Graves' interpretation of the evidence, the statements of Tomlinson, Smith and Nelson, which are lying over his upper body. And he's recognised the version given by PC Walker about him being on his knees with his upper body over the subject's right shoulder and him lying on his left side. There's no recognition in there of the high point of the Crown case which was stipulated in the letter of instruction. That's not mentioned there.
And I can't remember whether we did in fact have a witness saying he was completely over the top of Mr. Bayo.
So do you think that the letter of instruction was, do you not remember, or do you think that maybe was?
I just don't remember. I don't remember the details of each individual's statement well enough at this stage to be able to comment on that. I did at one stage, but not today.
Thank you. So we were at JAI, and I asked Mr. Wolfe about the position in relation to this, and he was of the view that it would have been a useful way to explore the factual issues with the expert if there were these potential variations in different versions, to adopt a method involving the use of hypotheses. And do you agree that that is a useful technique in how the Crown can discuss these issues with an expert?
I think, yes, I've already agreed that.
Right. And the letter of instruction did not present factual hypotheses to Mr. Graves. Either, obviously, they stipulated the lying across the body. There was no mention of Tomlinson, Smith and Nelson lying over his upper body as a factual hypothesis. And there was mention of Mr. Walker, PC Walker at the side of Mr. Bayo, but again, no factual hypotheses developed within the letter of instruction. And I'm wondering, looking at it now, do you think that would have been a very helpful technique to use in the letter of instruction with Mr. Graves?
I think the sentence that you took me to in the letter of instruction is quite general. It will cover all the situations that we saw, that we've talked about, beside, kneeling, half on, half off, fully on. It could cover all those things, and I think the expectation was that the expert would look at all those things, he having the source material.
And in terms of developing issues with Mr. Graves and exploring issues, to what extent did you explore those hypotheses with Mr. Graves, although they hadn't actually been addressed in the letter of instruction? So having heard evidence from Mr. Wolfe, and he talked about the use of hypotheses, was it part of your exploration of this issue to ask Mr. Graves if the facts are that PC Walker was lying, let me get this right, lying lengthwise on top of Mr. Bayo? Did you ask Mr. Graves, was that consistent with the actions of a hypothetical reasonable police officer?
I can't remember. I mean, those were the issues that were concerning us. Those were the issues that were highlighted in the letter of instruction. When I consulted with Mr. Graves, I was the second person to consult, because I think you told me already that Fiona Carnan consulted.
She'd recognised Mr. Graves, yes.
then it would be entirely consistent with normal practice for me to put the issues that we were concerned about to the expert.
So it would be normal practice to say, if the factual position is that PC Walker, 25 stone, was lying lengthwise on top of Mr. Bio during the restraint, was that consistent with the actions of a hypothetical reasonable officer? And to have that answer explored with the expert.
If that was not something that was dealt with properly in the report, then I would expect to question that and ask those questions, if I wasn't satisfied that I'd got the answer from the report.
And then another alternative hypothesis could have been that, as it says here, that Tomlinson, Smith and Nelson spoke to him being on his front with PC Walker lying over his upper body. That could have been another alternative factual hypothesis explored with Mr. Graves, and he could have been asked, would that be consistent with the actions of a hypothetical reasonable police officer? And equally, in relation to the version given by PC Walker, where PC Walker was on his knees with his upper body over the subject's right shoulder and him lying to his left side, equally you could have then explored with Mr. Graves, would that have been consistent with the actions of a hypothetical reasonable officer?
Yes, absolutely. And of course the expert has already dealt with those that position earlier on in his report.
Where in his report does he talk about factual hypotheses?
I don't think he says that, but he puts he has highlighted that he is aware of what's in Walker's statement.
Yes.
So he knows that that's one of the viewpoints or one of the positions of the witnesses.
But and you can correct me if I'm wrong, but I've read through the report and I don't see any factual hypotheses being put to Mr. Graves for his comment in the report. It's not part of the letter of instruction and it doesn't appear to form part of the report. Is that fair to say?
You've read through the report and I would agree. I wouldn't disagree with you.
All right, thank you. Do you think that was perhaps a missed opportunity to explore these different versions at an early stage in a clearly identified way, and to make it clear that Mr. Graves, that these were different versions? He wasn't being asked to decide which one was right, but to clearly identify what his opinion was in relation to the actions as described.
I think with hindsight, yes, it might have been better to ask the question. Would I expect those different hypotheses to be in the report? Not necessarily.
All right. And looking now, in the absence of clearly identified alternative factual hypotheses in the report, thinking now about the question that was posed in the letter of instruction, whether the method of engagement with and restraint of the deceased by officer was reasonable and justifiable, taking into account the requirement for the use of force to be necessary, accountable, proportionate, legal and ethical, does that add to you any concerns about the way the question is phrased, that perhaps you were inviting, or there was a risk that you were inviting Mr. Graves to form his own view about the facts?
I can see that there might have been a risk, and I can see your point. I'm not sure that at that stage it would have been a particular problem for us and for me with regard to my decision-making process. But I can see that looking back, if I was preparing for a trial, then I would want to explore all those different options with the expert. At the stage that I was looking at and the decision I had to make, I think looking at the letter of instruction, and from my recollection of what the expert had, I was sufficient at that stage. I was happy that it was sufficient for my purposes.
And obviously you weren't preparing for trial at this stage,
No.
but can you explain why you felt that was sufficient for your purposes, given you want to presumably have a very clear view about the opinion of the expert, and to make sure, as as Mr. Wolfe gave evidence, that it was, excuse me, give me a moment to find the phrase he used, but ultimately I think that it was important that the expert be given a clear picture of what the factual position could be. Sorry, I can't find the particular phrase, I read it out earlier. So do you not think that even though you weren't preparing for trial, that there would still have been merit and benefit in taking that perhaps more formal approach to the instruction of the expert and clearly identifying the different versions of fact?
I don't think I can disagree with that.
Thank you. Could we look at page 32, please? And I'm interested in L. And this again is Mr. Graves' report. I would also be very surprised that during this time PC Walker was not at times lying across the upper body of Mr. Byle and putting a degree of pressure onto him. I do not think this could have been sustained or prolonged pressure due to my comment in the next paragraph and continued resistance of Mr. Byle until full restraint was achieved. And just for completeness, at M, PC Tomlinson provides an example of this when he states that Mr. Byle was bench pressing PC Walker, who is a substantial weight, off the ground. In this position, the fact that PC Walker was on his back would not have placed any pressure on his chest if this was not on the ground, and Mr. Byle would have been able to breathe in this position. Looking at those two paragraphs now, looking at L in particular, do you consider that may give the impression that Mr. Graves was forming his own view about the factual position?
Yes, it might give that impression, but it also gives me the impression that he is considering the Crown case at its highest. So putting all his weight onto Mr. Byle.
Right. Well, he says he would be very surprised that PC Walker was not at times lying across the upper body, putting pressure on Mr. Byle. I do not think this could have been sustained or prolonged pressure. Do you consider that he was forming a view about whether that particular factual version was truthful and accurate?
I have to agree with that because he uses the words I do not think. I think if I disagreed with that, that would be quite hard for me to support.
And earlier today you talked about how it was simply not appropriate for a restraint expert to talk about medical matters, and that would be of absolutely no value to the Crown because he was not a medical expert. Did paragraph M cause you any concern when you read it, where he talks about pressure on the chest and whether or not, and his view on whether or not Mr. Byle would have been able to breathe in this position?
Yes, and that when I look at our report, I don't have to take everything in the report. Like an ultimate fact finder, I can look at bits that I can accept because of the experience and bits which I could say, well, actually, I couldn't lead that in evidence, or I wouldn't lead that in evidence because the witness is not in a position to say that. And so it's perfectly open to me when I get the report to look at it in that way, to look at it in a critical way.
And although that at the trial you wouldn't need to lead that evidence, but reading it before you consulted with Mr. Graves, did it cause you to be concerned that he was embarking on a course of action where he was forming his own views about the factual position, what the true and accurate version was, and he was going down, can I use a colloquialism, he was going down a rabbit hole? Did you consider it part of your role to perhaps draw him back from that? And again, would there have been benefit in setting out very clearly the alternative hypotheses and asking Mr. Graves to remain within those hypotheses and give his own views?
I think, yes, there's benefit in that. If the case had gone further, then that is perhaps something that I would do. I wouldn't ask him to change his report because that brings with it its own complications, but I might have discussed that particular paragraph and indicated that we might have come to the view together that that was not something that he really could express an opinion on.
And did you do that when you consulted with him?
I don't know. I suspect I focused on the things that were of real interest to me and not necessarily the things that I thought I might ultimately ask him to put to one side. I might have done, I just don't remember.
Was it not of real interest to the Crown, however, for the most prejudicial version to be absolutely clearly identified and to be discussed in detail with the expert?
Thinking back, I was happy that he had the absolute most prejudicial position. If you've looked at this and decided that he hasn't, then that is a matter for the inquiry.
Well, what I'm saying here in relation to L&M is that perhaps the perception could be that he was forming his own views, which may be, and again it'll be entirely a matter for the chair, but those views may not have entirely aligned with the high point of the Crown case.
Well, I can see that that you might think that when you looked at those paragraphs, but also alternatively you might look at other paragraphs and come to a different conclusion.
Did you want to clarify that with Mr. Graves when you consulted with him?
I can't remember.
Do you, looking at it now, think you definitely ought to have considered that and addressed that with Mr. Graves, given the concerns you've expressed about what may be the perception about these paragraphs?
I think as we've agreed, I might have thought that paragraph I was out with the expert L and M were out with his expertise, so it's maybe not something I would have explored further with him.
All right. And if we look at paragraph 33, page 33, paragraph V for Victor. He then goes on to say, whilst I am not a medical expert in such matters, I have dealt with and reviewed many such cases, and this is not one that jumps out as a typical case of positional asphyxia. It does have some of the hallmarks, but due to the short time of restraint, the constant movement of Mr. Bio, and his opportunity to take breaths during the restraint process, I do not believe this was a major contributing factor to his unfortunate death. And again, given he himself says, I am not a medical expert, is this the type of view being expressed by an expert that you would simply not consider to be of any value to the Crown?
Yes, I'd put that to one side. We already had some of that information directly from suitably qualified experts, so that would not even have registered with me beyond the fact he'd said it.
Knowing that it's there in his report, however, that you have an expert who's instructed in terms of his expertise regarding restraint. He's talking about medical matters. Did this raise a red flag with you in relation to why is an expert on restraint going out with his field of expertise? Is this something I should be concerned about? Is this something I should address?
It is a red flag, but it's not unusual with experts. I would want to satisfy myself that the things that he was telling us about, that he was qualified, had validity, and I was content with them. So if I compared this to the other pieces of his report that were properly expressed as an expert, then as long as I was satisfied with those particular paragraphs wouldn't cause me concern.
But as red flags, would you consider raising them during a consultation with Mr. Graves?
I might do. Perhaps in the way we might go to that paragraph and agree that that's not something that he is qualified to give an opinion on. I might even go as far as to check that it didn't colour that particular paragraph, didn't colour any of his other conclusions. But since I can't remember the actual consultation, I can't tell you whether I actually did that.
All right. I'd like to move on to his conclusions. So if we could turn to page 38. And if we could look at letter, if we can move down the page, please. Summary of conclusions, section 8, and I'd like to look at letter F for Foxtrot. And he says, in relation to all the variations in body position of Mr. Bio and the officers, I would suggest this fits with my explanation as to the fluidity of the control and restraint process, and that there were indeed times when Mr. Bio was face down and the officers were at times placing pressure onto him to keep him on the ground. However, I do not believe this was constant or prolonged. And I think in terms of the conclusions, where we see here a reference to my explanation and I do not believe this was constant and prolonged, again, looking at that paragraph now, does that give rise to any concerns in your mind?
I think I'd want to be clear that I was giving the expert the Crown theory at its highest, and that was our explanation and not his. And I can see the point that you're making about him being left to interpret the different statements.
And once you've given an expert the Crown theory, am I right in saying that you would then invite them to assume that that was correct and that was the true and accurate version, and then explain how a reasonably hypothetical officer would react to that version?
Yes, I would be, in this particular case, I would be putting the Crown case at its highest, because I'm not sure that the Crown were satisfied at that stage what exactly was the particular theory. So yes, I would want, as we talked about before, to put the Crown's case at its highest, but not necessarily saying this is the one that I am going to go with.
No, and indeed, I think we set out at the beginning of this series of questions that there may be different versions, and it's not for you personally to decide which one you prefer, just as it's not for Mr. Graves to decide which one he prefers and then proceed only along that basis. And you'd agree with that,
I do.
I think. I am going to move on now to look at the precognition of Mr. Graves, which was conducted on the 11th of May 2018. And I'd like to look at COPFS 00041.
Ms. Graham, it's just coming up to 3 o'clock, so we'll take a 15-minute break before you do that. Ms. Graham.
Thank you. We were about to move on to the recognition that was taken by the Crown of Martin Greaves. And if we could have on the screen COPFS 00041. Now, in evidence, Fiona Carnan had explained to the Chair that she had recognised Mr Greaves, but actually if we look at the very bottom, I think we can see not just her initials, but Alistair MacLeod's initials as well, AMFC. But if we can look at page 8, this is on the screen. What we have here is the recognition that was taken, and this is dated the 11th of May 2018. So it's after the report was initially sent to Crown. And I'm interested in the section that says, I am asked about what can be seen on Snapchat 1. Do you see that paragraph?
I do.
And he says, this looks to me like a standard position of team restraint. The first two officers go for the arms, the next officer takes control of head or legs. Standard setup. It looks like one officer is lying across the legs. From reading the statements, my impression was that this was P.T. Tomlinson lying across the legs of Mr. Bio. This position is shown in the training manual. I would say that P.T. Tomlinson, I believe, is lying diagonally across the legs as shown in that picture. It looks like a bog standard restraint position on the floor, trying to get leg restraints on. In my view, the police officer lying diagonally across legs corresponds with Tomlinson. I don't see anyone lying across the upper torso. I am sure PC Walker was at times lying over the torso of Mr. Bio, but that is not evident in that Snapchat. So again, subject to questions of what can be seen in the Snapchat, it would appear that Mr. Graves has been asked to look at the Snapchat and to express his own view about what can be seen on the Snapchat. And having read other statements, namely Mr. PC Tomlinson's, he has formed a view that PC Tomlinson can be seen lying diagonally across the legs. This appears to be a fourth version of the factual position which has been put, and this is in the recognition. Now, given what we've said about the high point of the Crown case, the alternative versions that have come out from our consideration of Martin Graves' report, and now this version, would you have expected the precognoser to explore those different versions with Mr. Graves and to consider the possibilities, or perhaps to address these different factual positions with him, to explore what was meant here?
My recollection of the information that we had was that the restraint was fluid, and although we might be able to identify particular people doing things at particular times, we weren't necessarily exactly sure that we were getting that right. And so what I see the expert being asked here and doing here is two things. First of all, looking at the images that he's been asked to look at and commenting on the positions of the different officers. And I think as far as that goes, that's perfectly acceptable, because he's looking at something and he's viewing it and he's giving us an indication of what he can see. I can see that what he goes on to do is try and fit together who's who, and perhaps that's not an appropriate step.
So would you have expected the precognoser to really explore this further with Mr. Graves, either within the precognition, or is this something that you addressed in the consultation that you had with Mr. Graves?
I think what I would be interested in is sitting with him, or the precognoser sitting with him and looking at the Snapchat, but not taking it any further with regard to the statements, leaving that for the precognition team, but actually taking him through what could be seen on the Snapchats and the CCTV, but not necessarily going to the stage of identifying particular officers. So that would give you the positions, but without that further element.
Right, thank you. Let's look at the consultation notes. We have notes in inquiry which bear to be consultation notes with Martin Greaves, which was in London on the 20th of August 2018, COPFS 02337. And your name and Les Brown's names are at the top. And there's 4 pages, or 3.5 pages, and what I perhaps you'd be willing to take from me is that there is no mention of factual hypotheses as part of this conversation. There is no clear identification of different versions or Mr. Graves' opinion on what a reasonable hypothetical officer would do depending on which version was being considered. There's no mention of a core Crown theory or Crown case at its highest or the most prejudicial version, and no mention of 3 or a 4th version as given in the recognition. Now, reflecting now and looking back, and given the issues that we've been discussing this afternoon, do you think that perhaps a better approach to make sure that Mr. Graves was reined in, speaking within his area of expertise and not making decisions about the factual evidence, not giving opinion on medical matters, that was an opportunity for him to, in a sense, be reined in slightly and to explore very clearly what the different factual versions were and what his views were about the actions of a reasonably hypothetical officer.
I can agree with you that that was an opportunity to do that.
And would you agree that that opportunity was not taken in August of 2018?
I can't remember, and if it's not reflected in the notes, then I can't go anything beyond that.
Now, yesterday I asked you about a very specific question in relation to the speed at which officers elected to use force against Mr. Bio. And I asked you if that was considered, and also whether, as a result of that, whether it was considered that it could give rise to any inferences or conclusions which might relate to bias, racial bias. And I think as part of your evidence on that series of questions, you expressed that it was very important that the OST expert could assist you with regard to what's normal, what's reasonable, what you would expect when a police officer arrives with the information that he has. So it was important that you knew exactly what the first officers knew, and those are the kinds of things that we would be looking for the expert to assist us with. We can look at the factual matrix, we can establish that as much as we can, but the expert would assist with that assessment of what hypothetical reasonable officers would do in that situation and within that timescale, that the speed of events. And I pointed out to you there was nothing really in the analysis which addressed that specific issue, and whether any racial motivation or racial inferences could be drawn. And I explained to you that I'd asked, for example, Fiona Carnan about that and Mr. Brown, and they'd said they hadn't addressed those questions.
I'm sorry, they hadn't addressed what questions?
The question about whether the speed at which officers had elected to use force against Mr. Bio could ultimately give rise to any inferences in relation to racial bias.
Okay.
They said they didn't consider the speed at which the incident occurred and whether that could give rise to any inferences regarding racial bias. And when I asked you about it, you thought that was something, as I understand your evidence, that the OST expert may have been able to assist with.
He would have been able to assist what a reasonable officer would have done, or the reasonable range of options in those circumstances.
And on the assumption, of course, that a hypothetically reasonable officer would not act in accordance with racial bias. Would you
course.
accept that?
Yes, absolutely.
So, again, taking from me, with the consultation notes, I cannot see any issues along those lines being discussed with Mr. Graves. So, did you discuss the speed of the incident, issues of race, possible racial bias? Did you talk about any of that with Martin Graves at the consultation in August 2018?
I don't think I talked about racial bias with Martin Graves. My recollection is that the speed of what the officers did at the different stages was something that was discussed, whether it was discussed at the consultation or whether it was in the report or whether I'd seen it in the precognition. It's certainly something that I'm aware was looked at, because from recollection what we were talking about was the chronology. So Officer X did that particular thing at that time within X amount of time being at a location. Was that reasonable? Is that what you would expect? Are there a range of options? The one that was chosen, is that reasonable or unreasonable? Those are the kind of things that I recall discussing. I don't recall discussing it directly with the expert because I don't recall the consultation, but certainly my recollection was that those are questions that he did answer. Did I discuss particularly racial motivation with him? No, I wasn't sure that that was something that was appropriate to discuss with him. I, of course, as we've talked about before, was looking at the mens rea element continuously, and I was looking at evil intent. If he'd said to me that was not a reasonable option, then I would be looking as to why that option was taken, and was there an explanation that there was some evil intent, and so perhaps a racial motivation behind that, supporting that evil intent.
So can you help the chair, when you say he looked at that question, but that is Martin Graves that you're referring to, when was he asked to look at that question about the speed at which officers elected to use force against Mr. Bio?
My recollection is that was part of his instructions. Now, I don't know whether it was in the letter of instruction, but he was asked, my understanding of what he was going to look at was the whole restraint period. So right from the start that they had attended at Harefield Road, right through. So not just the actions of the individual elements of the restraint, but the preamble to that with regard to batons and CS spray.
Right, maybe we should go back to the letter of instruction then, which was the 24th of January 2018. And I'm sorry, thank you. Let's look at the section that's headed up, page 6. Questions about PC's Walker and Payton initial engagement. Given the information available to those first two police officers, please provide your comment on the profile of the now deceased, the initial risk assessment by those police officers on their initial engagement with the deceased, and on their use of force. We've heard evidence that the first two officers at the scene who arrived in a van were PC's Walker and PC Payton. What, if anything, could or should the officers have done differently? Could you please address, in your opinion, the question of whether they ought to have been at that time alert to the possibility that Mr. Bile was suffering from drug-induced psychosis? Given the information to hand and his response to their initial engagement with him, if so, what, if anything, could they or should they have done differently in light of this in accordance with their training? Initial engagement by PC Short and Tomlinson. Constables Short and Tomlinson were the next two police officers at the scene. Neither of these saw a knife in possession of the now deceased, and there is varied evidence from the officers. I won't go into that. So in relation to the initial engagement and I'm happy to be corrected if I'm wrong, there doesn't appear to be any focus on a question for Martin Graves about the speed at which they elected to use force against Mr. Bio. But you think that perhaps that was something that was discussed with him at some point?
My understanding of those paragraphs is that is part of what we're asking him to look at. What, if anything, could or should the officers have done differently? In other words, rather than within X amount of seconds discharging their CS spray, could they have done something different at that point? And again, there's more detail in that last highlighted paragraph that we were looking at. Should the officers have made a different assessment? Should they have attempted to have talked Mr. Bio down rather than immediately moving to one of their force options? So that is what I had anticipated the expert would have addressed at that stage.
Right.
And that's to me what those paragraphs mean.
Right. Although it does not specifically raise that issue, but I'm wondering, looking at it now, with benefit of hindsight, do you think it may have been clearer to Mr. Graves if it had set out in relation to initial engagement, perhaps a question of what would a hypothetical reasonable officer had done if they had arrived at this particular moment in time, parked the vehicle, and within that period of time, this is what they could see at the scene. And would a reasonably hypothetical reasonable officer have elected to use force within that time scale? And would that perhaps have been a clearer way of identifying this particular issue to Mr. Graves?
Well, it's certainly a longer way, but I think perhaps the statement, what if anything could or should the officers have done differently, covers that situation that you've just highlighted. We could have put more detail in there in the way that you've just outlined, but as I'm looking at that now, I think that paragraph covers exactly what you've just outlined.
Do you see any difference between asking Mr. Graves what these officers should have done differently, or asking Mr. Graves what a hypothetical reasonable officer should have done in the circumstances?
I suspect that the thinking was that in asking that particular question in that way was that he would give us an example of what a reasonable officer would do in those circumstances. So if he formed the view that what the officers had done was not correct and was not reasonable, then he would outline, my understanding, what he thought a reasonable officer would have done. So in order to support the answer, I don't think they were correct, then he would have then have to go on and say, I don't think they were correct because here in my view is what a reasonable officer would have done.
So although there's no mention in the letter of instruction to the concept of a hypothetical reasonable officer, you would have anticipated that Mr. Graves would have come up with that himself and explained his position about what that reasonable officer should have done as part of his instruction.
He's the expert. He's the one that's coming in to tell us what the training is, what an officer should have done, why that training was in place, what he would expect in the different circumstances.
All right, thank you. Can I move on and ask you about another passage of your inquiry statement? Actually, I will not ask you that. What I would like to ask you is, I understand that you were instrumental in setting up what has ultimately become the Deaths in Custody unit that is part of SFIU. And I wonder if you could help the Chair understand the background to that unit. We've heard something of it, I think, from Les Brown in evidence, but I would be interested in your evidence.
Well, I don't know if I would go so far as to say I was instrumental, but I was certainly involved in the setting up of the unit, and I was involved with the pilot, the original pilot that ran for I think about 6 or 7 months, and thereafter I was involved, just as I was made Principal Crown Counsel, into in the involvement of the actual setting up of the full unit. So the deaths in custody unit was initially piloted, and I have some information in an email form, if I can refer to that, if that's
Please
okay.
do, yes.
Just so I can remember the dates.
Is this an email that was available to you from the inquiry team, or is it something that you would be prepared to give the inquiry?
No, absolutely prepared to give the inquiry. This is an email from one of the senior procurator fiscals in the CD unit. It's in response to an inquiry by me on the 31st of May of this year, just for me to refresh my memory with regard to the timeline. And so that's what it does. It sets out a timeline of the inception of the death and custody unit. And it confirms that initially the Lord Advocate gave evidence to the Justice Committee in November of 2021. And there was announcement that a bespoke unit was to be established, and it was bringing together the experiences of SFIU and of HSIU. At that time, the pilot unit was tasked with looking at a number of deaths, particularly in one of Her Majesty's prisons. And in December of 2021, there was a pilot commenced, and that was continued until August of 2022. At its inception, the role of the pilot was to consider deaths in custody due to suicides or drugs occurring after the 1st of November 2021, and to consider referrals of other deaths in custody before the 1st of November, where SFIU considered that these required to be considered by the Health and Safety Unit. And so it was potential at that time to identify deaths that had a potential criminal element as well in terms of health and safety. The custody death unit was formally launched on the 1st of August of 2022. And at that time, the unit started taking cases from the various SFI units.
So is it fair to say that expertise in handling custody deaths now is concentrated within the custody deaths unit which has been set up?
It is. There are some legacy cases, I understand, that are still being dealt with SFIU, but any of the new ones which are identified as coming within the remit of the unit are dealt with specifically by the unit. The unit also has a group of advocate deputies that are solely allocated to that particular unit. It's not the only work they do, but it's one of their specialist allocations. So there will be, I think there is about 10 or 11 advocate deputies, because it's quite a big area, that are allocated to the unit, and they will look at cases that are coming in from the death and custody units, and they will be marked specifically by those dedicated advocate deputies.
So in terms of the Crown Office staff, there'll be prognosers, solemn legal managers, and there will be advocate deputies who now have relevant experience in relation to deaths in custody and deaths following police contact.
That's correct. And the reason I was involved in the pilot was because I was involved in some other deaths in custody as well.
Thank you. And there are a number of ADs who have that special experience that can provide information and marking decisions for that unit.
There are. And that the learning and the knowledge and the training is shared between the unit and the advocate deputies. Any new advocate deputy who's allocated to that unit will be trained in the same manner and have the same materials. And the aim is to provide consistency with regard to the issuing of Crown Counsel's instructions. And what I explained to you yesterday, I think, was the template for Crown Counsel's instructions. That's also embedded into the instructions that we get from the CDU unit.
So if a death in custody or a death after police contact happened now, today, It would be directed and routed towards that unit.
It would be, and it would probably have an allocated deputy right from the beginning.
From the day it happened or
Yes.
thereabouts.
Yes.
And would that allocated AD be in a position to provide similar direction and instruction and assistance to the team in the sense that you've described yesterday when you were talking about that role?
Absolutely.
Thank you. Do you understand or have any knowledge of the reasons why that particular specialist unit was being set up?
Only from what the Lord Advocate had said to the Justice Committee, and to give them assurances that that was going to happen, that there was going to be a specialised unit set up.
And was it seen that that would be of benefit to the handling of these cases of this type?
Absolutely.
Can I ask you one last thing? In relation to after you had met with the Lord Advocate and you had discussed the issue with him regarding your decision, and I don't wish to ask you about that decision, can you recollect now what happened to the papers after that decision not to prosecute? Were the papers routed to another department to investigate issues of race or racial motivation?
I'm not sure about that answer, but I think ordinarily they would then sit with SFIU, because potentially there was going to be a fatal accident inquiry, and there would at that time more of the incremental work to be done before it was ready for a fatal accident inquiry.
Were you of any reason why progress couldn't be made at that stage in relation to investigating race, racial motivation, issues that were broader than perhaps would be more akin to the subjects and topics covered by an FAI rather than a criminal trial?
I think there could have been some investigation going on in parallel, and as you've heard, that is the way that we do that now, that cases are not dealt with, particularly deaths and deaths in custody or suspicious deaths are not dealt with in that incremental way. They are dealt with as much as possible in a much more collaborative way, where different units are involved in preparing at the same time. I think I've highlighted to you that one of the things that I thought might be possible to do once a decision was made with regard to criminality was to go back and take statements from the police officers or recognitions from the police officers. That, of course, could not happen until a decision on criminality was made.
And were you aware of any progress that was made in relation to that regarding the officers after the decision was made on criminality?
I think the decision on the next steps was made pretty quickly from recollection, and it was decided that the next steps would be potentially a public inquiry as opposed to a fatal accident inquiry.
Right. And the decision was made on criminality in around August 2018. And the decision on the public inquiry was the following year, as I understand it, 2019. Do you know what happened to the papers during that period?
I don't, but of course the distinction is that it's within the Lord Advocate's gift. It's part of his duties into investigation of death to hold a fatal accident inquiry or instruct a fatal accident inquiry is held. I don't, as I understand the procedure, it's not within his gift to do that with regard to a public inquiry. He can give advice, but he doesn't control the time frame with regard to the setting up of a public inquiry.
There was a VRR process that went on from 2018 and 2019. Now, during that period, was there anything to prevent preparation being done of the kind of matters that Ms. Graham's identified?
There was, and I'd forgotten about the VRR process because, of course, I'm not involved at all in the VRR process, and I don't even get to know what's happening with that for very good reasons. It's meant to be completely separate from the original decision maker. Beyond my comments with regard to the finality of criminal decisions, in other words, the steps could not be made to go ahead and take statements from police officers until there was a final decision with regard to criminality. I don't think that there was anything stopping further investigation, although my recollection was I was also asked to make a decision or give CCI with regard to a fatal accident inquiry, and my recollection is that was that discussion with the Lord Advocate and a wider team was pretty soon after I had issued my Crown Council's instructions.
Thank you. Could you give me one moment, please? Thank you very much. I have no further questions.
Are there any Rule 9 applications? Ms. Mitchell, any others? Ms. Edwards, would you mind withdrawing to the witness room, please, while I hear a submission?
I have 6 issues that I would like to raise. The first is in relation to independence, and this arises as a result of evidence that has been given by the witness about the independence of Crown Counsel. And that in particular was used to explain why there wasn't more involvement, for example, in obtaining details about the precognitions. In the independence of Crown Counsel is supposed to act as a check and balance within the system. And what I want to ascertain is what the weight of this procedural safeguard is. How is that independence shown? The witness stated that Crown Counsel's team is an independent team. A council of lawyers of advocate deputes. We're not part of Crown Office and Procurator Fiscal, so we provide independent legal advice and analysis on case, depending on the stage that we're at. And what I would like to ask the witnesses is there any structural independence from Crown Office? And by that, I mean, are the systems and processes that are used in the course of working the Crown Office ones, i.e., you know, where you work, what email systems you use, are they all part of the same body? The second question or second issue I'd like to ask also relates to independence, which is that the witness said that she would get involved at a high level in relation to precognitions. And she said that she didn't want to over-influence what was in a precognition. And what I would like to test with the witness is how does the involvement at all in this process sit with the idea of independence? There are 2 documents which I could refer to which relate to the witness asking questions, but I don't really think I need to go there. I think I can just ask it without going to those documents. The third issue I would like to ask about is the issue of tropes. Yesterday in the witness's evidence, she identified what I think was described as the angry black man in respect of tropes. I want to check with her if she identified those in statements which she read, and did she give consideration to instructing an expert in case she missed any tropes? And what I would like to ask her about specifically is there was an example given where Mr. Mayo, at that time unconscious, was lying down, and there's evidence that Mr. Payton slapped him twice on the face to see if he was unconscious or conscious, and to ask her whether or not she identified that as a possible racist stereotyping. And in that regard, I can call to the inquiry's attention SBPI 00515, page 20, which is a document from Inquest, which highlights another case where violence was done to a person whilst they were unconscious, to see whether or not they were really unconscious or whether or not they were faking it. And that's to identify that as part of a possible racial trope. And if the witness didn't do that, to ask her whether or not the instruction of an expert in race, for example, had been done before in the case of the white supremacist, would have assisted in the process. 4, tropes and Mr. Graves. My learned friend has been over at some length the letter from the Crown to Martin Graves, and she has touched upon this issue, but I would like to look at it in a slightly different way. For right or wrong, and putting aside the issue of whether it was appropriate to instruct an expert in that way, the Crown asked whether or not he was to provide an opinion on whether the behaviour was reasonable and justifiable, taking into account the requirement for the use of force to be necessary, accountable, proportionate, legal and ethical. And that's a direct quote from the letter. What I would like to ask this witness is if racial bias affected the perceived risk, for example, terrorism, the biggest man I've ever seen, superhuman strength, if that is racial bias and it's affected the perceived risk, ought that not to have been explored in relation firstly to the question of risk before you then go on to look at whether or not the behaviour was necessary, accountable, proportionate, legal and ethical, and whether or not that is something that should have been highlighted and explored. The 5th issue relates to a comment that was made about going the extra mile to unmask any motives. And I want to ask about that in the context of Article 2 and Article 14, because we focused, understandably, on the basis that that work was being done to ascertain whether or not there was criminality. But of course the duty was not just to investigate crime, it was to ensure that the state had complied with its duties under Article 2 and 14. And when the witness expressed the view about unmasking any motives, it of course is a reflection of the prohibition under Article 14. Authorities are under a duty to take all reasonable steps to unmask any racist or discriminatory motive and establish whether prejudice played a role in a death. Now, we've heard at length at this inquiry that about the police officers' views that this matter may be linked to terrorism. One of the officers indicated and linked it with the coloured male and the potential terrorist connotations. He was described as deranged with superhuman strength. He was described as massive, the biggest male I have ever seen. And what I'd like to put to this witness is we don't see anywhere an analysis done by the Crown of whether or not there was a discriminatory motive, and that can be a part of a more general motive, it doesn't have to be the only motive, or whether prejudice played a role in his death, and to ask, ought that to have been done by the Crown, and ought it to have been committed to writing, given the need for transparency and accountability. The final issue that I want to ask about is in relation to the comments made about Mr. Bayo's name and the links with Creole. You will recall that this took place in the context of whether or not the witness was correct when she spoke about the Afro-Caribbean population, and that was explained, and I think the inquiry should have the explanation from that witness quite clearly as to the process that went through and what that meant. However, my question is slightly different. The witness said this in her evidence: now, we have heard that Mr. Bayo was not part of an Afro-Caribbean population. He originally came from Sierra Leone. That was my learned friend counsel to the inquiry. The witness answered, I knew that, and I knew he'd come from Sierra Leone, and I think I indicated to you that I had done some research about the country and how it came into being. I think where, you will recall, I didn't have the papers at the time, my memory was that I looked at, following a consultation with the experts, I think it was Professor Lucas or Soilieu, one of the two, with regard to sickle cell anemia, I had looked at an academic paper where the prevalence of sickle cell gene, the recessive gene in the Afro-Caribbean population, had been discussed. And my recollection was I'd done a bit of research on that with regard to the makeup of the population in Sierra Leone. And there was a significant proportion of Afro-Caribbeans in Sierra Leone because of the way that the country had come into being. So I'll pause there. It seems to be that a link has been made with sickle cell, the recessive gene in the Afro-Caribbean community, and then a link with people in Sierra Leone. Now that must have been made because, of course, the family were from Sierra Leone. The witness went on, there were resettled slaves from South America, and I think this was why I was thinking of the Afro-Caribbean. That, of course, and the name, Mr. Bayo's name, which may be considered to have sort of Creole inferences. That's what triggered my memory. Now, the inquiry may not know, but Bayo is a Mandinko name. It's native of Africa. Sheiko's family have no connection with the Afro-Caribbean community, no connection with Creole. There is no slavery connection and no connection to the Caribbean. And what I would like to check with this witness, when she was looking at the name Bayo, was she linking the word bio and the name, which may be considered to have Creole influences, with the bio in the US? The reason that I'm asking this is this inquiry has to look at whether or not the Crown were taking the issue of race in a way where they looked at their own limitations and it may be contended should have got experts in. And I would respectfully submit this may be another example of the Crown adopting a path or looking at things they believe to be correct which simply aren't, and a reference to a race expert or speaking to the family themselves about it would have been able to avoid any of that particular issue. Those are my 6 issues.
Thank you. Well, in relation to the last matter, having regard to the evidence which the witness gave this morning, I do not think that I would be assisted by further exploration, but I will allow you to explore each of issues 1 to 5. We can make a start on that now, but we have to rise sharply at 4:15 and continue tomorrow morning. Can we have the witness back, please? Ms. Edwards, Ms. Mitchell, who represents the families of Sheku Bayo, has some questions for you. I think it's unlikely that we'll finish that because we have to rise at 4:15 promptly today. We'll sit until 4:15 and then we'll adjourn until tomorrow morning.
Okay,
Ms.
thank you.
Mitchell.
First of all, I'd like to ask about the independence of Crown Counsel. You explained to us why you were involved in some parts and less involved in others, and you explained to us by saying the following. So, Crown Counsel team is an independent team of counsel of lawyers, of advocate deputes. We're not part of Crown Office and Procurator Fiscal Service, so we provide independent legal advice and analysis on cases depending on the stage they're at. And then you sort of went on to describe that. What I'm wanting to do is really test where does the independence lie? And the first question I want to ask you is about structural independence. Is there any definitive structural independence between you acting as Crown Counsel and you acting in your ordinary course as an advocate depute?
No, they're one and the same.
Okay.
My understanding is that the classification of Crown Counsel includes the Lord Advocate and the Solicitor General, and as a whole, those are the Crown Counsel team, and Advocate Deputes are the ones below Solicitor General, so me and the rest of the Advocate Deputes.
So you've narrowed my questioning already because you've already answered two of the questions I want to ask you. I suppose, having identified that then, what is it that provides the independence from Crown Office and the Procurator Fiscal Service?
Okay. So Advocate Deputes are not employees of Crown Office and Procurator Fiscal Service. We hold our commission at the pleasure of the Lord Advocate, and it is the Lord Advocate that appoints Advocate Deputes, and the Lord Advocate can withdraw that commission at any time that he or she wants. Although we receive our remuneration from the Crown, we are contracted separately to work usually 220 days a year, and we, within the vagaries of the rota, we can choose how we allocate those 220 days.
So, you've anticipated again another one of my questions, which was about payment, and you are paid by Crown Office, but I understand that the difference that you make. So that's in terms of structural independence. I'd like to move on then to the second issue, which is testing the independence in a practical sense. In a practical sense, you indicated that if you read through a precognition, for example, and you thought more needed to be done in a certain area, you would say that you didn't want to over-influence something, but you might get involved in it to ask for something else to be done. Now, what I'd like to look at there is there, can it properly be said, if you're able to become involved in that way, that there is independence? Where is the line drawn? Is there indeed a line? Or is it a grey area as to how much you get involved and how much you don't in that process?
I think it very much depends on the team and the Advocate Depute, but I think we would all strive to make sure that there was a line and not a grey area. And I think practically what we would be careful to do is, if we need further work done, then we would ask for that further work done and that further analysis. But we wouldn't necessarily impose the answer before we ask for the further work done. Also, if we are consulting with the team, my personal practice is to try to make sure that I don't too much influence the actual answer, that I direct the team towards further information that would be of assistance to me without trying to impose my view on what I think is the correct answer.
I suppose in the asking of the question, that might give the impression that you are becoming involved or expressing a particular view if your question is pointed at a certain thing. And what I'm wondering is, from an external perspective, whether or not you can truly analyse that as indeed independent if you have any crossover at all.
I think it's a difficult line, but I think it's a line that advocate deputies tread very well day in and day out.
I would like to move on then, please, to the issue of tropes. You spoke yesterday about angry black man as a type of trope, and you said that you had read a number of statements but not all the statements. I am presuming you read all the statements of the relevant officers who were involved in the restraint.
Absolutely, and that is evidence to me at looking back by the fact that I was able to speak to the experts and also discuss different positions. I understand now, looking back, that I had quite a detailed knowledge of those particular statements.
Did you identify at the time that there were what could be identified as racist tropes in the police statements?
I think I said yesterday I didn't necessarily know at the time the word trope. I think I've come to learn that word over the intervening years, but I was aware of racist stereotypes. And I think at the time I was aware of the racist stereotype angry black man or big scary black man, but I don't think I would necessarily have called them tropes at the time.
The fact that you've accepted that you weren't using the word tropes and you had identified angry black man, would you accept perhaps that when you were dealing with this at this time, you were not best placed to be able to identify tropes?
Well, the inquiry will know more than me because you've taken evidence and the inquiry has taken evidence and about to take evidence. I was aware of racist stereotyping and how that potentially might influence what I was looking at, which was mens rea and evil intent. Whether it would have assisted me to know that particular word, I'm not sure.
Well,
I guess that's a matter for the inquiry.
Sorry, perhaps I'm not focusing on the word so much. That's perhaps my error. I'm focusing more on the types of racist tropes. For example, superhuman strength. Were you aware that that was one of the classifications?
I was, and I was aware that that was an issue here, and that my recollection is that we explored that not with anyone with regard to race, but certainly with regard to pharmacology.
And superhuman strength, he was the largest man I'd ever seen. Did you identify that?
Well, that fits in with the big, scary black man stereotype.
Did you, this inquiry has heard evidence about the use of force on Mr. Bio, and by that I mean that when he was lying on the ground he was slapped, and that was to see if he was unconscious. Did you identify that as inclusive and possible racial stereotyping?
I don't remember the slap, unless it was the police officer who first identified the fact that he perhaps was not breathing.
Yes.
And I don't recall if I knew if it was as strong as a slap.
It was. He slapped him twice. That was in the Perk statement.
Okay.
Just for...
No, I don't think so. I don't think that's something that really registered with me as inappropriate or something that would be racially motivated.
I see. I wonder if we can have a look briefly at SBPI 00515 at page 20. Just for the record, the statement where it appears the slap is Alan Payton's statement. That's COPFS 00262. Just in case the inquiry knows that. This is a document, Achieving Racial Justice at Inquests, and I wonder if we could scroll briefly to paragraph 20, or page 20. Scroll up slightly, thank you. Now, do we see here the heading, racial stereotyping can contribute to a culture of disbelief, characterised by a refusal to accept symptoms of vulnerability or distress as genuine. And if we can look here at the bottom of the first paragraph, it says, for example, the inquest into the death of Sean Rigg, a black man in mental health crisis, found that with his eyes, that doesn't make sense, sorry. If you go up to the top, found that failure to recognise Sean as a vulnerable person at the point of arrest and take him to accident emergency rather than a police station contributed to his death. Sean's death also raises how racial stereotyping can contribute to a culture of disbelief characterised by a refusal to accept symptoms of vulnerability or distress as genuine. And then it goes on, Sean had been subject to 8 minutes of prone restraint by police officers. He was taken to a custody sleep where he was slumped on the floor, down, with his eyes closed. Police officer said he was faking unconsciousness. And it goes on to another example of someone suggesting a black man was feigning or passing out as a ploy to escape. So there are issues, would you agree, arising from slapping someone in the face, which the inquiry has heard is not legitimate use of force. There are issues there which have been identified by independent experts on the matter as issues relating to race.
I would accept that that's what that says, and that is something that is a possibility.
In those circumstances, do you think, I've been able to show you just this as one example, would the instruction of an expert on race to analyse the language that was used by officers to assist with understanding what their perception of the situation was and what their perception of risk was, would have assisted the Crown in this case? For example, in the way that you used the white supremacist and got an expert report?
Potentially, yes.
I think that's as close to...
Well, thank you. So that's the end of your question?
No, I think that's as close as I can get to without embarking upon
For the next one. Right, well, we'll stop there and continue at 10 o'clock tomorrow morning.